Hello, my name is Joo-Cheong Tham. I'm a professor at the Melbourne Law School. On the 25th of May, the Vice Chancellor in email proposed a variation to the enterprise agreement. And a draft of that proposal was posted on the university website on that date. On the 2nd of June, the university posted the final version of its proposal. In this brief presentation, I'll explain the similarities and the differences between the original proposal and the final version. Let me begin with the similarities. There are two similarities between the original proposal and the final proposal. The first is a change that we're all familiar with, that is the foregoing of the salary increase granted on the 1st of May 2020, prospectively from 1st of July 2020, effectively a permanent 2.2% pay cut. The second stems from the Vice Chancellor's commitment or offering in his email the 25th of May for as much protection as possible for jobs. Like the draft proposal, the final proposal makes no commitment of that kind. Specifically, it makes no commitment to significant transparency regarding the university finances. It makes no commitment to limit the number of involuntary redundancies. It makes no commitment to address the number of job losses through non-renewal contracts, particularly the contracts of those in fixed term and casual employment. And these job losses are already occurring through the ban on hiring. Let me now turn to the differences. And when we think about the differences, we see the good, the bad, and the ugly. What is good by the final version is that, unlike the draft proposal, it will not reduce rights to information and consultation. And it will not remove access to arbitration by the Fair Work Commission. And both those changes are welcome developments. What is far less welcome and what is bad in terms of the final version is that, unlike the draft proposal, it does not provide any enforceable commitment not to stand down staff. And this is by contrast to what the Vice Chancellor stated in his 25th of May email, where he said that the proposed variation committed to not having any stand down of all staff. More significantly, the final proposal will still reduce redundancy entitlements. Now, the starting point to appreciate this is that the university is incorrect when it says that the redundancy provisions of the enterprise agreement only apply to what it dubs as involuntary redundancies. The redundancy provisions in the enterprise agreement, in fact, apply to all redundancies. And in saying this, I should note that this is consistent with the external legal advice that the university has commissioned, which does not speak, as the university has spoken of the redundancy provisions applying only to involuntary redundancies. Now, an important consequence of appreciating that these redundancy provisions apply to all redundancies is that without a single amendment to the enterprise agreement, the university could presently provide for a scheme where staff could express interest to leave the university, and that the university could, after receiving those expressions of interest, determine which staff receive separation packages. This could all occur without a single amendment to the enterprise agreement. What then is the purpose of varying the enterprise agreement to provide for a voluntary separation scheme? The purpose, it seems to me, is to provide for voluntary redundancies on the cheap, to provide for a scheme that bypasses the existing redundancy provisions. Presently, any voluntary redundancy scheme has to meet the requirements of the enterprise agreement as to redundancy pay and notice of termination. Under the voluntary separation scheme proposed by the university, on the other hand, inferior entitlements are provided. In this, the external legal advice received by the university is right to say that the voluntary separation scheme will, in its words, sit alongside the existing redundancy provisions. It is, however, mistaken when it concludes that the entitlements under the redundancy provisions are not reduced. It is true that the redundancy provisions will still be in the enterprise agreement. So much is true. But with the voluntary separation scheme, they can now be circumvented by provisions that provide for inferior entitlements. And the following table, which is available on the NTU branch website, explains these differences. Let me come to what's ugly. What is not mentioned in any of the university's correspondence is that the formula for voluntary separation pay under the final proposal provides for worse entitlements compared to the original proposal. This table explains the differences in these entitlements. And the entitlements in bold italics indicate those that have been removed with the final proposal. And this table, as with the previous one, is available at the NTU branch website. Let me conclude. The university is presenting its proposal as a plan to save jobs. Foregoing the 1st of May salary increase will, according to the university, protect approximately 200 to 300 jobs. The university says that, to quote, from the university's perspective, our proposed variation is the only variation under consideration. If not accepted through the ballot, we will move to implement other necessary actions to reduce the costs of the workforce. There is no necessity in any of this. All these are choices being made by the university management. The university can choose to address the impact of the COVID-19 pandemic in ways that do not involve varying the enterprise agreement to reduce working conditions. This is a path, in fact, taken by universities in less secure financial positions. Universities such as the University of Queensland and the University of South Australia. The university could also, like the University of Western Sydney, another university in a less secure financial position, commit to having no redundancies. And even when we put aside the vital question of the choices before the university and reflect whether the proposed variation will save jobs, the questions I continue to come back to are these. If this is a genuine plan to save jobs, why isn't there a commitment to protect jobs? Why isn't there a commitment to significant transparency in relation to the university finances? If this were a genuine plan to save jobs, why, on the other hand, is there a scheme proposed that will circumvent the current redundancy provisions under the Enterprise Agreement and provide for cheaper and quicker redundancies? Thank you for listening. I urge you to vote no to the university's proposal.